Hi, Frank Gray, partner with the law firm of Jimeno and Gray. We're going to talk about the divorce process, specifically choosing a cause of action for divorce in Maryland. Now, this may seem like it's a really simple topic, but it's actually a nuanced decision that you have to get right, because the worst thing you can do is to pick a cause of action that you can't prove. You're going to go through all the time and trouble of the contested litigation process and end up not getting anything that you're asking for. As always, if you're watching this on our YouTube channel, hit the like button for the video, subscribe to the channel, hit the notification bell so you know when we're pushing out more content that'll help you learn about family law. All right, picking a cause of action in divorce. Maryland is a really odd state because you really have to spend some time picking your cause of action. Understand the premise. Maryland is an old colonial state, one of the original 13 colonies. What that meant was they wanted to make it really easy for people to get married. Until Las Vegas was built, Elkton, Maryland was actually the marriage capital of the United States for several years. Why? The reason was because it was right off of I-95, so it was easy for people up and down the eastern seaboard to get to. You didn't need your parents' permission. You could get married young. There was no waiting period, no blood test. And Maryland just makes it really easy to get married. Even today, it's one of the easier states to get married in. What it's not is one of the easier states to get divorced in, because Maryland had a public policy of wanting to keep people married. We're going to talk about a few of the recent changes, but I'll tell you, it's still one of the more difficult states to get divorced in compared to colleagues that I hear talk about how easy it is to get divorced in New York or how easy it is to get divorced in California. So the first concept we have to talk about when you're getting divorced is, well, what kind of a divorce are you getting? There's actually two different kinds of divorce in Maryland. Not many states have different kinds of divorces, but there's a limited divorce and an absolute divorce. A limited divorce is not really what you think of when you think of a divorce. When you think of a divorce, you're thinking about an absolute divorce where everything is done and over. You can move on with your life. A limited divorce is a divorce for some purposes, but not others. A limited divorce allows the court to deal with child custody, to deal with alimony, to deal with child support, to deal with use and possession of a home and personal property. What it doesn't allow the court to do is to give you the right to remarry, to deal with marital property like pension distributions, and to give you your name back. If you took your spouse's name when you got married, you can't get that name back as part of the divorce process in a limited divorce, only in an absolute divorce. The only people that really get limited divorces are people who don't qualify for an absolute divorce. The only reason you might want to consider getting a limited divorce instead of an absolute divorce is so that one of the spouses can stay on the group health insurance policy of the other, because when you get an absolute divorce, you're going to be a prohibited person from continuing as soon as you get divorced. With a limited divorce, there are some plans that will let you stay as the spouse for the purposes of health insurance. I'm not even really going to talk about the cause of action for a limited divorce because they're basically the same as an absolute divorce. They just don't contain the same time limits we're going to talk about. So now let's talk about an absolute divorce. They fall into two different categories: fault-based ground and non-fault-based ground. Let's talk about the fault-based grounds first. First is adultery. That means that your spouse has had voluntary intercourse with someone other than you during the marriage and that you didn't forgive or condone it. You have to prove opportunity and disposition. It means you have to prove that your spouse had the opportunity to commit adultery, not that they were necessarily in a conference room in the middle of a day in a business setting, more like they went into a motel room with someone in the middle of the day. And you have to prove disposition. It means you have to prove that there's some degree of an amorous relationship between the two. It may be a note that one wrote the other. It may be a picture of them holding hands, something like that. Next is desertion. Desertion is actually two different causes of action. There's actual desertion and constructive desertion. Actual desertion for an absolute divorce means your spouse literally left you and you've lived separate and apart with no cohabitation for at least 12 months before you file. Constructive desertion means that you left your spouse. You have to prove that they made it necessary for you to leave to preserve your dignity, your health, your self-respect, and your safety. If that's lasted for 12 months after you left your spouse, you can file for an absolute divorce based on desertion. If that cause of action hasn't lasted 12 months, you could use it as a cause of action for a limited divorce. Next is imprisonment. This is a weird one. If your spouse was sentenced to serve 3 years of imprisonment after they served 12 months, you can file for divorce. The next is insanity. If your spouse has been institutionalized in a mental institution for a period of 3 years, after 3 years, if you can get 2 doctors to testify that your spouse is incurable with their mental condition, you can use that as a cause of action for divorce. Next is two causes of action that have kind of blended together over the year. There's excessively vicious conduct, and there's cruelty of treatment of the spouse or of a child of the spouse. They've kind of blended together over the years, and in the over 20 years I've been practicing, I've seen this area change quite a bit. It used to be that there had to be some sort of significant violence for a court to grant a divorce based on excessively vicious conduct or cruelty of treatment. I would tell you that in the more recent years, more contemporary judges, they just don't stand for any kind of violence, and any kind of allegation of actual physical violence will get you a divorce based on cruelty of treatment or excessively vicious conduct. Next are the non-fault-based grounds. Hopefully this is where you are when you're choosing your cause of action. If you've lived separate and apart for 1 year, which means you haven't cohabitated together, you haven't slept under the same roof, you haven't been intimate with each other after 1 year, you can file for a non-fault-based ground based on the 1-year separation. The next and last cause of action we're going to talk about is mutual consent. This is the newest cause of action. What this means is that you and your spouse both want to get divorced. You've come up with a separation agreement that deals with all of your issues: custody, child support, marital property, alimony. All of your issues are settled. If you tell the court you want to be divorced by mutual consent, they'll expedite that divorce for you. And you can even still be living together, unlike the other non-fault-based ground. There's nothing the court can do to stop you if you want to get divorced, even if you're still living in the same house. I hope you found this information helpful. As always, if you want more information about family law topics in Maryland, download a copy of the book.